One of the benefits of being the organizer of this conference is I get to go last. And in this case, it's really a question of last is least. So in any event, what I'm going to do in presenting this paper is discuss a work in progress. Special thanks to Tara Harrison for her research assistant on this, and many of my colleagues for numerous discussions about it. The paper I'm going to talk about is entitled Innocentrism. I'm all about the title. Come up with a hip title, people will read it. Form over substance. My title okay? Okay. In any event, American criminal law, here's the thesis. American criminal law is undergoing a transformation due to the increasing centrality of innocence-themed arguments in courtrooms, classrooms, and newsrooms. This is largely due to the advent of DNA technology and the use of that technological tool to free actually innocent prisoners. Indeed, there have been over 200 DNA exonerations since 1989. As a result, numerous law school innocence projects have sprung up across the land, including our very own Rocky Mountain Innocence Center. And state legislatures have responded quite favorably as well, passing a series of laws designed to facilitate access to biological evidence, as well as a number of other reforms designed to increase accuracy. Now, it may not be far-fetched to suggest, as others have done, that the innocence movement is the civil rights movement of the 21st century. Many folks, including a few of us, have praised this evolving focus on innocence, innocentrism, so to speak, whereas others, several prominent commentators, scholars, judges, etc., have come out to criticize it, suggesting that the innocence movement may not necessarily be a good thing. So my goal in this paper and in this talk today is in effect to critique the critics, to explain some of the most persuasive and persistent criticisms of the innocence movement, and then I hope try as best as possible to refute them. In doing so, my goal is to suggest that innocentrism, while far from a panacea to all of the criminal justice system's many ills, can be a complement to other criminal law norms and values. It's not designed to supplant these norms and values. It's something that is complementary rather than a replacement. So let me begin by trying to discuss some of the chief criticisms. And any effort to distill these multifaceted complaints into any linear discussion poses quite a challenge. I'll try to do so somewhat briefly. A review of the literature, at least my review of the literature, reveals three major criticisms that come to the fore. What I've labeled the crying wolf critique, Peter Neufeld crying wolf critique, collateral damage concern, and the effect on the not guilty concern. Let me just describe each of them in turn and then offer a few responses. First, crying wolf. The most persistent and persuasive condemnation of the innocence movement, in my view, relates to tabulation. What counts as an exoneration? Who counts as innocent? A number of folks have come forward to suggest that members of the innocence movement have artificially inflated the overall number of wrongful convictions by counting factually ambiguous, dubious cases on the innocence side of the ledger. In particular, a person named Josh Markey, the former president of the National District Attorneys Association, has looked at the data set and suggested that, in fact, the error rate in our system is infinitesimal, under 0.03%. Data that Associate Justice Scalia cited in the case of Kansas versus March. This is a number that is greatly below the various figures that have been thrown out by empiricists associated with the innocence movement, which generally range from about 3% to 8%. So the argument from this perspective, the crying wolf perspective, is essentially this. By alleging that innocence projects inflate the overall number of wrongful convictions, the intimation or insinuation is that the innocence movement is mischaracterizing the problem, that in fact the system is working quite effectively. So that's the first major critique. Innocence projects are crying wolf. The problem is not as dire as many folks claim it to be. Second major critique, which I'll call the collateral damage argument, and it emerges from a particular law school in a Midwestern city that will be obvious in a moment. It's a law and economics argument. It's basically as follows. It's basically this. Even skeptics who acknowledge that or believe that the innocence movement has mischaracterized the problem, even those skeptics tend to admit that perhaps some innocent people fall through the cracks. Why? Because like any system devised by human beings, the criminal justice system cannot be infallible, whether it's the Kenney-Monroe 1% error rate or not. Now, the argument on this respect, basically goes like this. If it is inevitable that actually innocent people are going to be convicted, what should we do about it? Now, most skeptics will say that this episodic problem is still a problem. If there is a true case of actual innocence, let's investigate it and overturn it. Other folks will say the inevitability of error is an acceptable outcome in exchange for the societal benefit of having an efficient and not overly costly system. In other words, having a criminal justice system in which some innocent people go to jail is like most governmental regulatory decision-making to begin with. After all, any government decision that's designed for the good of the majority will obviously or almost invariably inure to the detriment of a few folks. Take, for instance, and this is the argument that's been made, any decision to raise highway speed limits to ease the flow of traffic. That's something that's done with the eye of benefiting the majority, most of us, law-abiding drivers who need to get from Salt Lake to Provo as quickly as possible, or more likely the other direction. But by raising the speed limit, the inevitable cost, of course, is either that there'll be a greater number of vehicular accidents, and or if there are the same number of accidents, there'll be greater damage due to the increased speed. So that's a conscious decision by government. This resembles, in my view, collateral damage in war. Most war planners in getting ready for a campaign don't actually intentionally, objectively want to kill civilians. Some people might disagree with that assertion, but it's my view that that is not a conscious objective of most military planners. However, in planning for a particular campaign, most military planners acknowledge that inevitably some civilian casualties will ensue. But that's a cost of doing business, because the overall good of this campaign justifies sacrificing the few. So that's the second argument. Some innocent folks are going to go to jail. That's just the cost of doing business. And this is a conscious decision by our publicly, democratically elected government. The third concern comes from the left. Concerns from both the right and the left have been raised. Let me just summarize this concern, which I call the effect on the not guilty. Now, at first blush, one would think that criminal defense lawyers would love the innocence movement, right? It seems like a great thing for criminal defense lawyers. It makes it seem like criminal defendants may in fact be guilty, that they're not all scum. And to an extent, some criminal defense lawyers have found the innocence movement to be quite compelling. But numerous defense lawyers and leftist criminal law scholars have looked askance at the innocence movement for a variety of reasons. There are basically three sub-arguments. Let me just mention them briefly. The first is the idea that the innocence movement has tainted the jury pool. Every time we read about a guy getting out of Sing Sing, freedom, all this stuff, what do we begin to think? Well, people might be innocent. People are going to be innocent. So jurors going into the jury selection process and going into the trial process are going to begin to look far and wide for cases of factual innocence. Well, guess what? As my colleagues have indicated, the vast majority of criminal defendants are not innocent. They are unequivocally, factually guilty. So some folks on the left have basically said the innocence movement is tainting the jury pool. Jurors are going to look for factual innocence, and they're going to neglect their obligation to only convict upon proof beyond a reasonable doubt. That's the first of the leftist critiques. The second leftist critique basically goes as follows. The use of innocence-themed arguments to justify legislative reform. And I'll be unabashed about this. We do this all the time. We did this yesterday with our session. We use members of the innocence movement, and I count myself one of them, we use innocence-themed arguments. Look at the poor Darrell Hunt case, for instance, in North Carolina, to justify a number of legislative reforms, be they changes to the way in which we conduct eyewitness identification procedures, in videotaping police interrogations, and the like. Some scholars have come out and said, this is bad, because the passage of legislative reforms that are accuracy-related, designed to actually get the bad guy and exclude the good guy, those are bad for criminal defendants. Why? Because most of them are guilty. So if you fund state crime labs more, that'll just mean that they'll be better at their jobs and catching the bad guy, putting my clients in prison. And the third critique is a little more ethereal. And the idea is essentially this, that on a macro level, this whole innocence movement aura provides a conceptual distraction. It diverts attention away from more pervasive, systematic flaws in the criminal justice system, flaws related to constitutional rights, procedural violations, errors that are, by all accounts, much more frequent. Nobody in the Criminal Law Academy, and maybe I'm going out on a limb here, would disagree with the assertion that there are more Fourth and Fifth Amendment violations in this country than there are wrongful convictions. So in terms of their frequency at least, constitutional violations, procedural violations are more endemic, more pervasive than wrongful convictions. So some leftists have said, you know, innocence really has this intuitive, visceral appeal. This is bad for fairness-based arguments. Because when you talk to legislators about innocence, they're going to begin to turn a deaf ear to the Constitution and to procedure. Because it's much better to talk about that tangible, tactile, innocent person than it is to talk about these loosey-goosey abstract principles, if you can refer to the Constitution as loosey-goosey. Okay? So those are essentially the three major critiques: the crying wolf critique, collateral damage, and the effect on the not guilty. Now, in my remaining time before we take questions, I just want to offer my futile attempts to counter these critiques. The first relates, of course, to the crying wolf critique. And I'll start off with the proposition, and it's not a far-fetched one, I think, that the true number of wrongful convictions is unknown and frustratingly unknowable, in the words of Professor Sam Gross at Michigan. Why is this the case? Because not every instance of actual innocence is ever brought to the attention of a litigator or a judge, let alone yields an exoneration. Why? Inmates who are imprisoned may become despondent at their plight and give up. This happens. Inmates in prison who have biological evidence available in their case, that evidence might become lost, destroyed, or degraded over time. And in the 80 or 90% of cases with respect to which there is no biological evidence available for testing, these inmates encounter significant procedural roadblocks and conceptual obstacles from judges. So I think it's fair to say, and I don't know if I'm going out on a limb, I'm mixing metaphors here, that this is the tip of the innocence iceberg. No limbs on icebergs, I guess. But it does seem as though this is the tip of the innocence iceberg. The numbers that are out there are just a smattering of the true number of wrongful convictions. Nevertheless, what constitutes a proven case of actual innocence is instrumental to the debate, and it goes to the very credibility of the innocence movement. Therefore, folks like Josh Markey and Paul Cazell, if I may include you in this, provide an essential oversight function. Folks who are looking at these cases and examining them provide this very important function. They ensure that the innocence movement is reputable. They ensure that we do not count things as exonerations based on our own insular analysis. It's very important to have outside scholars and practitioners vet these cases thoroughly and make sure that we are actually being accurate. The question then becomes, how do you define an exoneration? Given that DNA is so rarely available, we shouldn't ask for 100% certainty, scientific certainty. That would be too high a bar. But short of scientific certainty, what should be the standard? Should we ask for an official, judicial, public declaration of innocence, say in the form of an appellate decision or an executive pardon? Well, a lot of exonerations happen behind the scenes. Prosecutors and criminal defense lawyers cut deals on a post-conviction motion and agree jointly to release the defendant prior to an evidentiary hearing on the case. Or a new trial motion might result in a new trial, and the prosecutors will simply choose not to retry the defendant because they don't believe they have enough evidence to do so. Are those cases of actual innocence? Are those just cases of legal innocence or actually true factual innocence? Necessarily defining exoneration reflects a value judgment along a spectrum of varying degrees of innocence. Of course, we should aspire toward absolute certainty. That's the objective. But that doesn't mean we should shun common sense. The mere possibility of guilt after somebody's released from prison, in my view, should not foreclose the categorization of that case as an exoneration. Now, in terms of the collateral damage argument, here's my view of this. Sure, it's inevitable that wrongful convictions occur. We're humans, humans make mistakes. However, as a normative matter, it seems unclear to me that the government is consciously contemplating the wrongful conviction of a few innocents for the greater good of the criminal justice system. I suppose that implicitly the government is doing so. Whenever the government draws lines, statutes of limitations on habeas petitions, or restrictions on funding for expert witnesses for public defendants, that might be an implicit acknowledgement that there has to be some line drawn, and a result of drawing that line is that some folks won't get the zealous defense that they require, or they won't be heard in court, and therefore errors may be made. However, isn't the bulwark of our criminal justice system perhaps the most fundamental principle in our system, the idea that it's better to let 10 guilty go free than one innocent person remain incarcerated? If we assume that that is the foundation upon which the Anglo-American criminal justice system rests, then I think it's very difficult to equate the criminal justice system to government regulatory decisions generally. Two reasons in particular why I think this is a poor analogy. First, the experiences of people harmed through wrongful convictions differ substantially from those who are harmed through the regulatory process. Folks who are wrongfully convicted are necessarily stigmatized for years to come by the fact that they've been indicted, spent time in prison, spent years in which they were unable to develop a work history. This is not necessarily the case for somebody who's injured through a regulatory decision. Second, injuries in the regulatory arena typically derive from individual choice. We choose to drive, though there's a risk of dying. We choose to eat beef, though there's a risk of it being contaminated. We choose to take prescription medications, even though there's a risk of unforeseen, untoward side effects. Is that the case in the criminal justice system? Do all of us wittingly agree to participate in the criminal justice system as criminal defendants? Presumably none of us do. None of us make that conscious decision, unless merely breathing on earth means that you've made a choice to become the potential object of a wrongful conviction. To that end, wrongful convictions, in my view, are not incidental byproducts of a system designed to achieve the greater societal good. Rather, they are clear demonstrations of the system's failings. And last, I want to take on the left here, the effect on the not guilty. The idea, of course, from this perspective, is that the innocence movement undercuts those time-tested criminal law norms and values that have been in vogue since the Warren Court, the constitutional rights and procedural protections that should be afforded to each and every one of us. That's what folks from this perspective are arguing. This is a problem. Innocence undercuts fairness-based arguments. Let me just respond to those arguments. First, my view is that defendants will not, with respect to the juror tainting sub-argument, my view is that criminal defendants will not inherently be disadvantaged by having jurors hear about tales of wrongful convictions. And here's why. We've all heard that in literature there are only two stories. The person goes off to make her fortune and then returns home. Well, in criminal law there are only three. There are three defenses. He didn't do it, mistaken identification, alibi, pick your poison. Second, he did it, but it was justified or excused, self-defense, insanity, necessity, duress. And third, prosecution can't prove it. We don't know. That's all it is. Three defenses, and you can sort of shift how exactly you frame it. The only one of those defenses with respect to which innocence is at loggerheads is number two, the justification or excuse defense scenario. In those situations, having jurors who come in really focusing on factual innocence could be a problem for a criminal defense lawyer. Because you're arguing your guy did it, it should be justified or excused. But isn't that exactly what jury selection is designed to do? What voir dire is designed to do? To weed out potential juror biases? Is innocence any different than any other type of social phenomenon or issue of the day that defense lawyers and prosecutors regularly have to ask jurors about in voir dire? Like the CSI effect or something like that? Can't criminal defense lawyers simply ask jurors about innocence and exoneration when in fact they know that their defense is not going to be based on actual innocence? And even more, with respect to defense lawyers who pursue theory 1 or 3, didn't do it, prosecutors can't prove he didn't do it. Wow, aren't wrongful convictions good? Because what wrongful convictions have done is they've undercut one of the premises upon which many jurors approach cases. Well, The police have figured out this guy did it. The prosecutors have charged him. He must have done it. The fact that wrongful convictions are in the news completely annihilates that idea that the police and prosecutors on the front end get it right. So isn't this revolution a strategic boon for criminal defense lawyers in those cases? Second, with respect to the legislative reform argument, and I'll echo a little bit what my co-panelists said before. Many of the legislative reforms that have been implemented in the aftermath or as part of the innocence movement are good for both the factually guilty and the actually innocent. Giving more money to the defense bar is good for all defendants. Ensuring that other types of protections, such as the use of jailhouse informants, that the use of jailhouse informants is a little bit more limited, another reform that's been advanced, that's good for all defendants. The only reforms that may not be good for factually guilty criminal defendants are those that are purely accuracy related. And the question I give for you is maybe that's a good thing. Maybe that's not such a bad thing, for a couple of reasons. The first is even those accuracy-related reforms can still result in battles for criminal defense lawyers. If you give more money to the state crime lab, that might mean more discovery for criminal defense lawyers to utilize and make hay with at trial. If you allow for the videotaping of interrogations, that might also allow criminal defense lawyers to argue that the police were badgering their client, even if their client's factually guilty. It might even give factually guilty clients a greater ammunition. And last but not least, by having a more accurate system, or by having laws that perhaps favor accuracy over fairness, might that just add to the legitimacy of the system? After all, in a more accurate system, who's actually going to go to trial and forego a plea bargain? The people who are innocent, presumably the people who are innocent. So the only folks going to trial in a more accurate system are the ones who may have a better innocence claim to begin with, which will inure to the benefit of the defense bar. And last but not least, on the macro level of theory, this idea that innocentrism is a distraction presupposes that innocentrism supplants those Warren Court values that we hold near and dear. And my view is that they are just complementary rather than a rather than supplanting those values. And here's why. It boils down to a very simple premise. Innocence cases are different. Innocence cases are different than cases premised on fairness concerns, concerns about constitutional violations and procedural protections. And here's why. In innocence cases, it's all about the facts. From jury selection through your opening argument, through your witness prep, through closing, through the appellate process, it's the facts upon which you, as a defense lawyer, are hanging your hat. What about constitutional violations and procedural protections? If your argument is based on fairness, if your theory of the case is fairness-based as opposed to accuracy-based, you're hanging your hat on legal errors, issues that are far removed, usually, from the eyes and ears of jurors. The battleground in those cases, it occurs in the pretrial suppression motion stage, or in camera evidentiary rulings with the judge, outside the presence of the jury, or in post-conviction filings, or in appellate briefs. Again, those are completely different cases. Innocence is not necessarily going to distract educated judges, presumably, right? And innocence is not something that should be viewed as a detriment to time-tested values. So in conclusion, the goal for this paper is, as I said, to critique the critics. But in doing so, I am not, and I want to reiterate this, suggesting that innocentrism will solve all of our problems, but just that it's a complement. It's a nice new tool in the woodshed of the criminal law discourse. Thank you. And at this point, we'll field questions.